though our expert today has a niche practice in a particular area of law, which we call as competition law, but the topic that we will be discussing, which is bid rigging, is something that I'm sure all of you, if you're practicing lawyers, all of you must have come across these concepts called government contracts, government bids, and companies participating in these contracts. And more than that, you must have come across these topics like, okay, bids are getting rigged. Now, there are a lot of law enforcement agencies that deal with these issues, but the primary agency which actually is in the top with respect to dealing with this issue is our Competition Commission of India, that is CCI. And Competition Commission of India very extensively looks into bid rigging cases. And we have Mr. Rahul Goel with us. Welcome, sir, for our session today. Sir is a partner at Indus Law. He is heading the team of TMT and competition and has years of experience dealing with competition enforcement and merger related matters. In fact, sir has actually headed the team which was appearing and which had represented 𝗥𝗵𝗂𝗹 in the matter before the Supreme Court, which we call as our landmark case in terms of bid rigging. The first time the Supreme Court actually came out with a proper judgment as to how bid rigging cases should be dealt with. So I'm very glad that we have sir with us who can provide us first-hand information on what this issue is all about and how does the CCI actually deal with it. Most importantly, what do we understand from bid rigging? What are the forms of bid rigging? And what are the landmark cases that have happened? How does the CCI and the Supreme Court actually, identify bid rigging? Because you must have observed that whenever companies are submitting their bids for any kind of government contract, there's a lot of, you will see there's a lot of case of identical bidding based on the market. So how does the CCI actually differentiate between the two? To say that, oh no, in this particular bid, there has been a collusion, but in this bid, there is actually no collusion. They're only responding to market forces. This is very, very essential even for in-house counsels who are working with these companies that take part in government contracts. They must be very good with civil laws and constitutional laws, but they are completely unaware of how the CCI deals with these matters. Also because they don't have a good experience with competition law. So I thought let's conduct this very much needed webinar on this topic. And I'm very glad that we have sir himself to share his insights. So once again, sir, thank you so much for agreeing to come for this webinar.
So thank you so much, Shweta, for this, and good afternoon, everyone. Thank you for inviting me for this session. So the topic that we would be covering is a topic which is good enough for a PhD, to be very honest. And I think 1 hour would not be sufficient to do complete justice to the topic. But let me try to explain some of the broad concepts that we deal under the Competition Act with respect to bid rigging and cartels. And so the presentation has been now divided in 2 parts. The first part of the presentation would deal with the procedural aspects under the Competition Act, and the second part would deal with the bid rigging aspects under the Competition Act. So I would leave it completely on to the moderators here, whether they would like to ask questions in between or towards the end, but feel free to note down your questions and seek clarifications on whatever you think is important. In terms of making it a little more easier, I'll share a short presentation.
Sure, sir. Sir, if I may just request you to come a little closer to the mic.
Okay, sure.
So that because your voice is absolutely clear.
Yeah. So is it better now?
Yes, sir, much better.
Audible? Okay, perfect.
Yes, sir.
So
I'll request everybody to, while we conduct the session, just so we have a lot of people, we have around 60 people. So I'll request everyone to be on mute. Secondly, if you have questions, you can continue posting them on the chat box. And after the end of each segment, we'll take up the questions. Okay, so that we ensure a smooth flow of the session. And wherever, if you guys feel that there is some hearing issues, just put on the chat box. Okay, so guys, are we cool? Can we start with the session now? Just say like a yes, no, maybe, so that I understand that there's a constant engagement between the two of us. Okay, perfect. So great. Perfect. Yes, sir. Let's actually begin.
Shweta, is the screen visible? Can you see the?
Yes, sir. The screen is visible.
Perfect. So we'll first start with some of the basic concepts under the Competition Act. I'm not too very sure whether all of you are very well versed with the Competition Act, or whether you have
Yes, sir.
dealt
We
with
have some
Competition Act.
students. We have some students who are from the course of competition itself, but so they are aware of the provisions. But we have a lot many other students who may not have dealt with competition law before.
Okay, perfect. So I think this is basically for the beginners and people those who have not dealt with the Competition Act. Some flavor as to where Competition Act works and to whom it applies.
Yes.
So the Competition Act was notified on 20th of May 2009 and applies to all entities. And in terms of the Act, it says any person, department of government, any individual, HUF, company, a firm, association of persons, corporation of any nature would get covered by the Competition Act, and it would apply to all economic activities as well. Now the activity has to be something which is related to production, storage, supply, distribution, acquisition or control of articles of goods or provision of services of any kind. The only exception which has been settled by the Delhi High Court in Indian Railways versus Union of India is the activity of the Government of India, which is relatable to the sovereign function of the government, including atomic energy, currency and defense. So barring these three broad areas, each and every activity which is conducted by the government departments also gets covered under the Competition Act.
Absolutely.
Now, in terms of the process flow chart under the Competition Act, once the CCI receives a complaint or a suo motu reference, CCI would have two options. One, to look at that initial complaint or information, pass an order saying that there is no prima facie case which is made out, and close the matter under section 26(2). Once a matter is closed under section 26(2) of the Competition Act, the parties would have an option to file an appeal before NCLAT and subsequently an appeal before the Supreme Court against the order of NCLAT, which is a very, I think, simple and streamlined process. The second is wherein the Commission thinks that there is a prima facie case and this case now requires an investigation by the Director General under the Competition Act. So in that case, CCI would pass an order under section 26(1), would refer the matter to the Director General for investigation. The 26(1) order is also called the prima facie order. DG, on the basis of prima facie order, would investigate the matter, would prepare a detailed investigation report and the recommendations, and that DG report is then supplied to the Competition Commission of India or the CCI. Subsequent to receipt of the DG report, the CCI would then pass on the report to the parties, would ask the parties to provide their written statements and submissions on the DG report, and then would hear the parties before passing the final order. And subsequently, CCI would pass a final order. So if the final order is in the nature of section 27 order, wherein a penalty is imposed or a cease and desist order is also passed, the parties would then have a right to appeal that order before NCLAT, and subsequently an appeal from NCLAT's order would lie before the Supreme Court. So this is a very general, generic flowchart in terms of the process in a competition. Now, some of the important relevant provisions that we generally rely upon while dealing with the competition cases are, to start with, section 2C, which defines cartels. Then an information is filed under section 19(1) of the Competition Act. I'm sorry, 19(3) talks about, and this is the typo, it's not about dominance. 19(4) talks about dominance. So 19(3) is the section which gives the factors for anti-competitive agreements, and the factors under 19(3) have been dealt in the subsequent slide. 20. Okay, again, I think there are two typos there. So 21(1), it's basically 26(1), which is prima facie order, DG to investigate. 26(2), no contravention, final order is passed and the matter is closed. Under section 26(4), the DG report is circulated to the parties. If the CCI thinks that there is no contravention and DG report says no contravention under section 26(5) and 26(6), then the matter is closed.
Yes.
27B is the section wherein the penalty is imposed by the Competition Commission of India, and we'll deal with that penalty part subsequently. Now, the other relevant provisions are 36(1), which basically state that the CCI would be guided by the principles of natural justice. 36(2) grants the power of civil court to the CCI. 39 is a section which is in terms of failure to pay the penalty. I'm so sorry. 41(1) is the power wherein the DG is directed to investigate as per the direction of the CCI. 41(2) is same as 36(2), granting powers of civil court to the DG. 43 is failure to comply with the orders of the DG or the CCI, wherein the penalty is 1 lakh rupee per day, going up to 1 CR. Similarly, if you give a false statement, then section 45 is the section which gets invoked, wherein the penalty is up to 1 crores. And you obviously have the lesser penalty provisions or the leniency provisions, which are covered under section 46 and subsequently covered by the lesser penalty regulations.
So the voice is again a little low. I think you went a little further away.
Okay. Let me come closer now.
Yeah.
So section 48 is one of the most contested sections under cartel cases, when the penalties are imposed on individuals. Section 48 is currently under judicial challenge before the Delhi High Court, and also would be argued before the Supreme Court on 7th of October in a couple of cases to see whether it can be applied in competition cases at this stage. Then you have 53A and 53B, wherein the orders of the CCI can be appealed before NCLAT. Now, interestingly, if you would see the sections which have been mentioned, 53A and 53B, section 48 is missing from that list. 53N is the compensation applications subsequent to an order of the CCI or NCLAT, a party which is aggrieved by the conduct of opposite parties can move an application seeking compensation or damages before NCLAT. 57 talks about confidentiality. Section 60 is act to have overriding effect. 62 is again application of other laws not barred, and 64 power to make regulations. So section 60, 62 and 64 are general provisions which are available under all laws, and 62 and 60 have both been dealt in great detail by the Bombay High Court and then subsequently by the Supreme Court, and the cases which have wherein the jurisdiction of the TRI was also contested.
Yeah.
Now, when a 26(1) or the prima facie order is passed, so this is the first stage of initiation of investigation by the DG in a cartel matter. Now, what would a 26(1) order have? So 26(1) order should have allegations, would also state the names of opposite parties, prima facie findings given by the CCI. It may also talk about the relevant product, the market and the geography. A direction to the DG to investigate the matter. It would also state whether the company and the individuals both have to be investigated or company alone has to be investigated. Now, one of the current debates that we are facing is whether these 26(1) orders are open-ended orders. Whether an open-ended order can be passed by the Competition Commission of India in a prima facie scenario. Now, once the matter reaches the DG stage, what would you expect? So, DG would issue a notice to the party seeking responses, information and data. Now, the first thing that a person who is looking at the notice have to consider is that what is the scope of the notice? What is the product or service under the investigation? Whether the request under the notice as excessive. Whether the DG has sought details of other products or services which are not part of the 26(1) order. Also, the important aspect in terms of these cases is during the course of investigation. So in 𝗥𝗁𝗵𝗂𝗶𝗵𝗁 case, Supreme Court has held that if during the course of investigation, if DG comes across any other contravention, then that contravention can also be examined by the DG. So that during the course of investigation becomes a very wide terminology. So now the DG would have the power to look at something beyond 26(1) order if it emerges during the course of investigation that the company possibly may have violated that particular section. Now, the DG generally also seeks email dumps and call records from the parties. What you can do is that as a party, you can seek confidentiality on the data which is given to the DG. You can also place reliance on the legally privileged data. And if the allegation has not been told to you, then obviously you can raise a concern with the CCI or the DG in terms of the allegation. You can also demand the order which has been passed by the CCI under 26(1). And you can also look at and raise objections with respect to the unreasonable timelines, or if there is a denial of extension on timelines by the DG, CCI. So in a normal course, once a notice is issued by the DG generally grants 2 weeks for submission of the data or the information. But practically we have seen that in a lot of these scenarios, the parties generally find it difficult to meet those timelines because the request is excessive, the data which has to be collected is quite exhaustive. So normally you would go back and seek extension from the DG to provide that data, and which is a very regular process. Now, in terms of the DG investigation, what is it that you would look at as a counsel? That the DG investigation is fair, it is transparent, there is no confirmation bias, and also the principles of natural justice have been adhered to by the DG. Now, there is a debate, an ongoing debate at this stage whether the principles of natural justice would apply to the DG also or would only apply to the Competition Commission of India. But nevertheless, I think PNJ is one concept which can be applied to even the investigation procedures, especially under the Competition Act.
So can I just revise the process to them, because I can understand there were a lot of provisions that they must have.
Yes, please. Please.
Yeah, so guys, the major takeaway over here is that, as lawyers, you should just understand that what is the process that the CCI is taking. So like Sir showed in his chart that, okay, first, there is an information that gets filed. So if you are working for a company that is suspecting that, okay, a bid rigging is happening, let's say there are some companies that are colluding and are rigging the tender, then you approach the CCI, you file an information under section 19. If the CCI feels that, yes, there is a legit case, I on a prima facie basis, I am satisfied that there's a case, then CCI will send it for investigation. And the investigation will be conducted by someone called the Director General. Okay, this is when a 26(1) order is passed that, okay, now I want this matter to be investigated. Another scenario with Sir said also happens that CCI feels that no, there is no legit case, the information is very flawed and there's actually no collusion happening, and the CCI will dismiss the case. That is under section 26(2). Now, if the investigation happens, after that the DG comes out with a DG report saying that, okay, we have interviewed all the colluding participants, we have interviewed all the stakeholders, we have done a detailed study on the market, and we have come to this result. Okay, now after coming to this result, whether the DG will say that yes, a collusion has happened or a collusion has not happened, either of the two stand the DG needs to take. So after that, the parties will get their chance to give their submissions to the DG report, which we call as the final hearing. Okay, that in the final hearing, the parties give the suggestions. And finally, if the CCI feels that, okay, yes, the DG report was correct, there is a violation that has taken place, even after the submissions given, then the CCI will come out with a penalty. Otherwise, even after the DG report, the CCI may say that no, I'm sorry DG, I don't think there is actually a case of collusion, and the CCI will close the case under section 26(6). Okay, and beyond that, sir explained right now that when the DG is conducting investigation, what are the relevant data that the DG will take from you as a company. So as an in-house counsel, you should know that, okay, these are the documents that the DG can investigate. Search and seizure powers are given to them in order to conduct the investigation and come out with a DG report. So is everybody clear with the process? Before we actually move on to bid rigging, this was like a small introduction we wanted to give to competition law as to how the process goes on. Okay, so if everybody is clear, then we'll move on to the next segment. Okay, I can see Niharika says it's clear. Okay, yes. Yes, sir.
So can we continue now?
Yes, sir.
So couple of other things in terms of the DG summons. That DG, there's a legal representation which is now permissible. Now in terms of regulation 46 and 46A, it says that not at a hearing distance. So what we have seen now is that the DG would generally ask the legal representatives to sit in a separate room with a glass wall in between, and that has become a very routine procedure in terms of legal representation. That part of legal representation is also under challenge before the Delhi High Court. There could be a coercion, seeking access to mobile phones and email accounts, email dumps, call records, and cross-examination are some of the relevant issues which we face very regularly in terms of the DG investigation processes. Some of these have already been raised in plenty of cases, are either pending before the High Courts or the Supreme Court of India. During the course of investigation, what is it that you can do? You can inspect public records. You can look at public versus confidential records as an ongoing debate. Photocopies of the documents, principles of natural justice, grant of extension, examination in chief, and cross-examination are two vital issues. Access to complete records and evidence is something which is of prime importance to all the opposite parties. Again, this is one of the most contested topics with the CCI at this stage.
Absolutely.
Now, what if the DG says contravention and CCI disagrees? Then you have two cases to rely upon: Prince India versus Springer, which was Compat's order, then subsequently 𝗿𝗵𝗂𝗶𝗏 𝗏 versus CCI, which is known as Purvangra case before Delhi High Court. So the DG says there is contravention and CCI disagrees, and CCI closes the case, then the possible option for you, for any party would be, or informant would be, to go under the writ jurisdiction before the High Court, because those orders are not appealable currently in terms of 53A. The penalty has been, the penalty provision under section 27B has been dealt by Supreme Court in 𝗥𝗵𝗂𝗶𝗏𝗧 case, which is one of the most landmarkish cases for bid rigging and cartels, wherein the Supreme Court said that in case of a multi-product company, the penalty should be levied on the relevant turnover, or that is the turnover which is under contravention. Interest on late payment, regulation 5 of the CCI, manner of recovery of monetary penalty regulations, is also under judicial challenge before the Delhi High Court. The power of the CCI to review and recall its own orders has been settled by two orders of Delhi High Court division bench. One is DDA versus CCI, and then subsequently Google versus CCI. Now Google is pending before the Supreme Court. CCI subsequently filed an appeal against the order of Google before the Supreme Court, and which is likely to be heard in the first week of October by the Supreme Court.
Yes, sir.
Then you have access to documents, which is 𝗏𝗏 versus CCI, Delhi High Court's division bench's order, which would give you some clarity in terms of how the documents have to be accessed. Legal representation against 𝗏𝗏 and Oriental under regulation 46 and 46A. Now, as mentioned earlier, regulation 46 and 46A are also under judicial challenge before the Delhi High Court. So these are the cases which you can, possibly read whenever you have time, which will give you some better understanding in terms of how the things are moving before various courts in India.
Yes,
cross-examination has been settled by 𝗖𝗵𝗂𝗏𝗂𝗏, which was the first cross-examination granted by the CCI, which can be read in Lupin's case before Compact, and 𝗏𝗏𝗏𝗏, the Compact's order. Then PNJ was settled in cement cartel case, obviously, and apart from that, KCD and 𝗏𝗏𝗏𝗏. Now is the next segment. I think we have spent around 30 minutes in terms of looking at the first part. The next segment is about bid rigging and horizontal agreements. Now, in terms of section 3, which deals with horizontal or anti-competitive agreements in general, it says that no enterprise or association of enterprises or person or association of persons shall enter into any agreement with respect to production, supply, distribution, storage, acquisition, or control of goods or provision of services which causes or is likely to cause an appreciable adverse effect on competition within India. So the term causes or likely to cause an appreciable adverse effect on competition is very important, and secondly within India. So what is anticipated here is that in case of any cartel which is happening in terms of the export market and not dealing with India, possibly would not be covered by section 3. Section 2B gives that very broad definition of agreement. It can be any arrangement, understanding, and action in concert. Can be formal, informal, oral, or in writing. In any form, if there is an understanding, arrangement, or action in concert, then that would get covered by the definition of agreements under section 2B. 19.3, as mentioned earlier, talks about the factors which have to be kept under consideration while passing a 26(1) order or a section 27 order by the CCI, which would include creation of barriers to the new entrants in the market because of the conduct of the players at the horizontal level, driving existing competitors out of the market, foreclosure of the competition by hindering entry into the market, accrual of benefits to consumers, improvements in production, distribution of goods or provision of services, and promotion of technical, scientific, and economic development by means of production or distribution of goods or provision of services. These are the factors which the CCI would take into consideration while passing the 26(1) order, and subsequently while examining the DG report to pass the final order possibly under section 27. I'm not getting into the definitions here. I think generally section 3.3 is known to everyone. It talks about enterprises, association of enterprises, or persons, or association of persons. But most importantly, it talks about practice carried on or decision taken by the entities which are engaged in identical or similar trade of goods or provision of services. Now, there is an ongoing debate which is also pending before the Supreme Court whether section 3.3 or section 3.1 has to be read along with section 3.3, or whether section 3.1 can be invoked independently without section 3.3. Now, the horizontal agreements of this nature would be deemed that they have an appreciable adverse effect on competition, and therefore these would be void if the agreements directly or indirectly determine purchase or sale price, limit or control production, supply, and markets, technical development, investment, or provision of services, shares the market or source of production or provision of services by way of allocation of markets. And lastly, which is the current topic, directly or indirectly resulting into bid rigging or collusive bidding. Now, bid rigging has been explained in the proviso to section 3.3. It says bid rigging means any agreement between enterprises or persons referred to in subsection 3 of section 3 engaged in identical or similar production or trading of goods or provision of services which has the effect of eliminating or reducing competition for bids or adversely affecting or manipulating the process of bidding. Now, the important aspects here are in terms of eliminating or reducing the competition is one part. Then adversely affecting or manipulating the process of bidding is the second part. So any action by the parties which would fall in any of these two categories would be considered as bid rigging. Now, bid rigging, can be of many kinds. So, what would you call a bid rigging? So there can be different scenarios wherein you have a bid suppression. wherein I would not, I would file a bid at a lower value, or I would rotate the bids between the competitors, which would be bid rotation. I would file and agree in terms of filing the identical bids that the markets or the quantity can be equally distributed between the players, or I would file a lowest bid. Also, cover bids or the complementary bids, which are essentially to show that there are more than 2 or 3 parties in a tender process, would get covered by this 4th bullet. And also the agreement of the parties not to bid against each other, which is quite like bid rotation in some sense, would also be called bid rigging. So any process wherein any of the competitors, before the bids are filed, would agree on any of the aspects with respect to that particular bid, would get covered by the process and the terminology of bid rigging. And this would obviously include the price fixation.
So guys, is everybody clear with respect to what is a bid rigging? The definition that we saw in the previous slide. So as sir was explaining, different kinds of horizontal agreements, which are basically agreements that are entered into between competitors. Like today, I'm manufacturing cement, sir is manufacturing cement, and we get together and collude and rig the bid completely. Okay, we ensure that we know each other's pricing, the quotation that we're giving. Okay, this is a form of what we call as a horizontal agreement. That on a horizontal level, parties are colluding with each other. And bid rigging is one such form of horizontal agreement. And these are the types of bid rigging that you can see. All companies that engage in this kind of a collusion will always form this kind of a system amongst each other. Either they will suppress the bid, or they will go in rotation, or they will give identical bids, which is, I guess, sir, the most common form of bid rigging that we are seeing. And sir can later on explain that, okay, how does CCI look into identical bids or complementary bidding, or just deciding that I am not going to bid against you. So you win this particular round, I'll win the next round. So yeah, I hope, I think everybody's clear on this part. So yeah, sir, we can proceed.
Okay. So the bid rigging, the concept of bid rigging has also been explained by the Ministry of Finance, Department of Expenditure, and their Manual for Procurement of Goods 2017. So for them, they state that, which is very similar to the definition of the Competition Act, promise on the part of bidders not to enter into any undisclosed agreement or understanding with other bidders with respect to prices, specification, certification, subsidiary contract, etc., would get covered by the process of bid rigging. So this is a definition, which is a different definition, which has been independently adopted by the Ministry of Finance as part of their Manual for Procurement of Goods with respect to all the public sector undertakings and the government agencies. So essentially, when you talk about bid rigging is an important subject because, as you would know, that 30% of the GDP is essentially in terms of public procurement. So it constitutes a large part of what government spends on, and accordingly bid rigging becomes a very important aspect in terms of government procurement. And traditionally, looking at the way India has worked in the past 70 years, all the traditional entities or undertakings, not essentially from the service sector but mostly from the goods sector, have been participating actively in public procurement processes. And accordingly, the process of participation in these tenders becomes an essential mechanism to monitor how the companies have been, acting and bidding in these contracts. Now, I think, some of these terms we would also relate to when I'll talk about the 𝗥𝗵𝗂𝗶𝗁𝗏 case and the LPG cylinders case. But again, going ahead with the Manual for Procurement of Goods, it says that cartel formation, pool rates, bid rigging, collusive bidding, etc., quoting of these things is against the basic principle of competitive bidding and defeats the very purpose of open and competitive tendering system. Now, ministry and the departments are then directed to look into these aspects, and if they feel that there is any cartel formation or there is bid rigging or collusive bidding of any kind, then report that to the Competition Commission of India and also to the CVC. And subsequently, the government entities have been instructed to debar the party, those who have been involved in bid rigging and collusive bidding kind of processes. Now, one of the important aspects when we talk about the bid rigging part is that, generally how would you say there is a bid rigging? So, you would see a continuous trend of parties quoting the same rates over the years. So you would pull out 40 different tenders of the same product, and you would see that, over past 3, 4, 5, 6, 10 years, the parties have almost quoted the same price. That is one aspect. Or you would see a trend wherein, the parties are now allocating the quantity. So, there would be a bid rotation or there would be a bid suppression, and in one tender, the first party would get the tender, in subsequent one, second would get it, and third party would get it. And there is obviously this kind of an allocation of the tenders between the parties. So that becomes an important indication for the commission or for the government undertakings to see that, whether there has been a bid rigging kind of a thing which is happening. So the large number of cases in terms of the bid rigging have been filed by the Ministry of Railways before the Competition Commission of India. And some of those cases, the ministry has been successful. In some cases, the CCI has closed the cases by saying that the process of calling of tenders or procurement is itself bad, and the government is required to change those processes. Now, one of the important aspects in terms of you noticing a similar price trend or a parallel pricing, so to speak, is also because of fall clause which the procurement manual gives. So in terms of the fall clause, and which is part of all the government tenders, it states that if a bidder quotes a lower price in a subsequent tender or quotes a lower price to some other party, then they are required to reduce the price in the tender which has already been closed with the government entities. Now, from the government standpoint, they call it a price safety mechanism, but from a competition standpoint or a party which is bidding, it is essentially a tool or a forceful tool which is now adopted by the buyer to tell me that you cannot change your price or you cannot sell your goods at a lower price to somebody else. But as soon as you would sell your goods at a lower price to somebody else, you would have to offer that same rate to me. Now, effectively, what would happen is that in no circumstance I would be able to charge a higher price or quote a higher price in a subsequent tender, because that fall clause will automatically take in the subsequent tender. And also under no circumstance I would be able to quote a lower price, because if I quote a lower price in a subsequent tender, I would have to revise my rates in all the tenders which have closed previously. And this is an effect which essentially comes out of the way the tenders and the bid documents have been drafted or are being drafted by the government entities. There is no single case at this point in time wherein anybody has challenged the fall clause itself before the Competition Commission of India.
Right.
Now, one of the important questions that emerges from this entire debate of fall clause and the public procurement is that can enterprises be in violation of Competition Act when the prevailing market conditions are themselves not conducive to a competitive market? Now, this is an important question, and I think Supreme Court has to some extent answered this question. for the opposite parties. But this is still an ongoing debate in all the public procurement cases which are currently going on. Now, one of the first cases in terms of public procurement which reached finality was the 𝗥𝗵𝗂𝗹 case. Now, 𝗥𝗵𝗂𝗹 case talked about the market conditions. It talked about the concepts of monopsony and oligopsony. Although both these concepts were not dealt by the Supreme Court in 𝗥𝗵𝗂𝗹 case, but subsequently dealt by the Supreme Court in the LPG cylinders case. So monopsony, oligopsony is a situation wherein you would have small number of buyers. You would also have small number of manufacturers. Like in 𝗥𝗵𝗂𝗹 case, the buyer of aluminium phosphide, the product which was under investigation, a 3-gram tablet, the buyer was only Food Corporation of India, Central Warehousing Corporations, or the State Warehousing Corporations. And all these 3 entities are government-owned entities and they work very closely with each other. So in any scenario, if a party A would quote a lower price at any of the State Warehousing Corporation tenders, the others would follow that same price and would direct the suppliers to quote that same price in the subsequent tenders. You have only 4 manufacturers in this market, UPL, Excel, Sandhya and Agrosynth, and subsequent to that case, Agrosynth closed down the business, so you had only 3 players in the market, UPL, Excel and Sandhya. So effectively 3 buyers, which are all government buyers, and only 3 manufacturers in that market, which is a clear and I would rather call it a case of monopsony from the competition standpoint. Now, the way I mentioned that, in 𝗥𝗵𝗂𝗹, if you would read the judgment, you would see a chart which would give around 40 tenders and the prices quoted by the entities in those tenders, starting from 2002 until 2011. And if you would see that chart, you would get a feeling that the parties have quoted exactly the same price in all those tenders. Now, one of the arguments in that case was that because of this market situation, which is either monopsony or oligopsony, the parties cannot change the price. And there was an instance wherein one of the parties quoted a lower price in a tender floated by some warehousing corporation, and subsequently the other warehousing corporation directed Excel to reduce the price and match the price as quoted by Sandhya. So essentially we are talking about a concept of monopsony, oligopsony, and also the buyer power, wherein the buyer would have a power to direct a certain price and a price which has to be quoted by the suppliers in a particular market, and this would essentially become a market condition which would definitely or should be treated as a mitigating factor in most of these cases. Now, this entire concept of monopsony, oligopsony, market power, buyer power was dealt in detail in the LPG cylinders case, which is also Rajasthan cylinders case. Now, in that market, again, you had 3 or 4 oil marketing companies which were buying the 14.8 kg cylinders, extremely limited number of buyers. The product was pretty standardized, so everybody would know exactly how to make the cylinder and what would be the specifications. The only buyer was the government, the oil marketing companies. You also had entry barrier, so you had limited number of players in that market. And apart from the L1 getting the tender was awarded and equally distributed between lowest 1, lowest 2 and lowest 3. So there was effectively no incentive which was available to the parties. Everybody would know that what the manufacturing process is and what the cost of manufacturing is. So these are the factors which were taken into consideration by the Supreme Court, and the Supreme Court said that there was no scope for competition. Price parallelism is inevitable where the buyer has high degree of control and determines price, quantities and even the identities of the awardees at its discretion, which is again the market behavior and the buyer power. And there cannot be any appreciable adverse effect on competition because of the above factors. The Supreme Court further noted that in these situation of oligopsony, this market condition led to a situation of oligopsony that prevailed because of limited buyers, and influence of the buyers in fixation of prices was all prevalent. So essentially they said that whatever is happening in this market is essentially because of the conduct of the buyer, which is called the buyer power under the Competition Act, and not because of the suppliers or the bidders. And accordingly, in this case, CCI said that there is no violation of Competition Act under Section 3.3, read with 3.1, and there has been no appreciable adverse effect on competition. Now, one of the important and interesting aspects of the LPG cylinders case is that out of the 50 parties, one of them at least admitted before the CCI that there were meetings which used to happen and the prices in the markets were distributed among the bidders. So even after looking at that aspect, if there is no appreciable adverse effect on competition, then essentially there cannot be a violation of Section 3.3. This is what the Supreme Court held. Now the other case is the case of public sector insurance companies, which is again a case of a public procurement. So 4 of the public sector undertakings came together, discussed the prices and filled in a tender for an insurance scheme which was floated by the state of Kerala. And while they went before the CCI, they said that we are a single economic entity. The agreement between single economic entity cannot be examined under the purview of Section 3.3 because we all are owned by the government, and government owns the majority stake or full stake in terms of all the 4 public sector insurance companies. Now what CCI held and subsequently was also upheld by the Compact was that if you act and operate independently of each other, then you cannot have this argument of single economic entity available to you. So even if you are owned by one particular entity, which is government in this case, but all your actions throughout and the management is independent, then this argument of single economic entity would not be available to you. Now, in terms of the entire competitive agreements, and if the Commission feels that there is a violation of Section 3.3 read with Section 3.1, and now accordingly they want to impose a penalty. Section 27 is the provision wherein the Commission has the power to impose penalty. They can discontinue, or they can direct discontinuance of the agreement or termination of the agreement. The penalty, the monetary penalty, can be up to 10% of the average turnover of the last 3 years, which can also be the relevant turnover depending upon the circumstances and how the parties argue the relevant turnover before the CCI, or 10% of the turnover of the each year of continuance of the cartel, or 3 times the profit for each year of continuance of the cartel, whichever is higher. So in the cement cartel case, CCI used the third part regarding profits and imposed a penalty at 0.5%, 0.5 times the profits for each of the entities in contravention. And the third part of the CCI, is CCI can order anything else that it deems fit under Section 27. Now, some of the cases which are important cases for your reading in terms of cartels and bid rigging. Obviously, the first one is 𝗥𝗵𝘂𝗹𝗁 Limited. It deals in detail in terms of the price parallelism kind of a concept, the market power, the buyer power, and obviously it lays the law in terms of relevant turnover. Rajasthan Cylinders is again a very important case from the public procurement standpoint because it deals with the concepts of oligopoly and monopoly and talks about buyer power in detail and also kind of lays them as the mitigating factors. It also clarifies that if there is no appreciable adverse effect on competition, then Section 3 is not violated, even if the parties have met together and quoted the same price. The cement cartel case is an important case to give an indication as to what could be the instances of collection of evidence by the CCI and the DG to hold a party in contravention of the Competition Act. So the cement cartel case has been has gone through various rounds of litigation before CCI as well as Compact. And my strong suggestion here would be that it is important for everyone to read the first round of CCI and then the first round of Compact, then second round of CCI and the second round of Compact, to give complete clarity in terms of how the commission moved and laid the law in terms of principles of natural justice. The oil marketing company's case is currently under investigation, which is also a case of public procurement, wherein the oil marketing companies are involved. And you would see a lot of text around oil marketing company cases, which is now pending adjudication before the Delhi High Court because of the concurrent jurisdiction of PNJRB, which has been invoked by the oil marketing companies. And obviously the case of public sector insurance company, which I just talked about, which talks about the single economic entity. And I think these are the 4 or 5 broadly the cases which deal with public procurement and would be of great importance in terms of understanding how the CCI is looking at these cases. Now, in addition to these 3-4 cases, I think the foundation of the competition law can be understood through 𝗵𝗵𝘂𝗹, the judgment of Supreme Court, which led to amendment of Competition Act in 2007. Subsequently, Steel Authority of India Limited versus Union of India would be another important case for you to understand the scope of 26(1), the scope of 53A, and the powers of the DG to investigate. One other case which is not mentioned here is not essentially a competition case but has a great relevance to the competition regime, is the Bhajanlal case, which deals with the power of review and recall, that under what circumstances can the review or recall take place. Would be definitely an interesting read to understand the competition law. Again, when we talk about the competition law, and as rightly put by Shweta in the very beginning, that competition law in itself is a very nuanced space of practice. But we draw a lot of influence, and rightly so, from CPC, civil procedure codes, and also from the Constitution of India. So a lot of the judicial challenges at this point in time and the cases which are pending before the high courts are essentially placing reliance on the provisions and the jurisprudence under the CPC and also articles of the Constitution of India. So in order to be a successful competition practitioner and to understand how the cases have to be dealt before the CCI, I think a great understanding or a deep understanding of CPC as well as Constitution of India is equally important.
Absolutely.
I think Shweta, that's broadly it, and I will open the floor for questions. So if you have any specific questions, I'll be happy to answer those questions.
Yes, so we have some questions, but before that, I actually had 2 questions which are very specific to bid rigging given the current scenario. That now we have a lot of people saying that, okay, COVID-19 is going on, because of which I'm sure there has been a change in attitude of the CCI as well while approaching the cases. And while reading, I came across that there have been 2 orders passed recently where the CCI did consider and did hold that a bid rigging was in place, but the CCI did not levy any penalty. It only asked the parties to cease and desist. So, in this kind of a scenario, what is your perspective on what kind of impact can these orders have in the future of jurisprudence, especially with bid rigging, like owing to COVID-19? What kind of impacts will such orders have where penalties are not being levied, only a cease and desist order, that too for a thing that has already happened? They've already rigged the bids.
Correct. So Shweta, I think the fundamental thing which emerges from all these cases is the cooperation part with the DG.
Yeah.
And CCI in both these cases has clearly recorded that the parties have cooperated fully with the DG. In the second case, the CCI came and wrote to an extent that the parties have not filed leniency, but still the content of the parties was towards giving a lot of evidence on the cartel and disclosing the cartel to the DG during the investigation. So cooperation became a very important aspect of all these cases. Now, not levying the penalty is one part, because ultimately everybody has been talking about that you have to bring in awareness about the Competition Act. And by
Yeah,
imposing
deterrence
huge
effect, as
penalties,
we call it.
you are not achieving anything, because everything is either stuck at the appellate stage or at the Supreme Court level. So even if you have imposed penalties of, like, in case of 𝗥𝗵𝗂𝗹𝗏, the penalties were brought down to, the relevant turnover. So essentially, the
Right.
agenda should not be in terms of imposing the penalty, but also but to educate people to have proper compliance to Competition Act and the competition laws. So
Absolutely.
this new trend would obviously help Commission, kind of market itself well, by telling the parties that, we are sensitive towards your economic conditions, but we would only request you to follow the law and not contravene the law. So this is the message which has been sent out by the Commission at this stage.
Right, right. And so this question is for in-house counsel, because I had in the course that we have for in-house counsels, and when we were dealing with government contracts, a lot of them asked this question because they said that we know that matters have gone before the CCI in cases of bid rigging. So how would you, if you were to advise an in-house counsel of a company that is taking part in government contracts, how would you advise them to advise the companies while they are taking part in such government contracts, so that they do not come under this radar of bid rigging?
So I think the first and the fundamental thing for all the companies, especially the companies which have been, taking active part in government procurement processes, is to have a in-house compliance mechanism available, and a training session available to everyone. So what we have seen is that, in most of these cases, the violations are done by the marketing teams, and which are not fully, legally aware about the provisions. So those are the ones who would go and meet with, their competitors, who would talk to the competitors, would divulge information. For them, this is a very casual chat, but essentially CCI would not look at this as a casual interaction or a discussion. So it is important for the in-house counsels to train these set of people and tell them that, look, this is what if you'll do, will violate the Competition Act. And it will not only, risk or, create a risk for the company, but also for the individual himself. Absolutely. Because ultimately a penalty under Section 48 can also be imposed on that individual who would have given that information out. So one part is that to have an independent compliance manual and a training given to all the employees, especially those who are participating in the bidding processes, and to also then keep a check and a look, a watch on the price trends and the mechanisms, which the company is following over the years in this public procurement processes, to see and identify whether there is a trend of bid rigging, collusive bidding, bid rotation, bid suppression, or any of those factors. And if they see that, there's a trend of continuously parties quoting the same price over the years, then the legal counsel should raise that as a red flag within the company and seek answers and create proper documentation for that purpose. But there is no cartel. If there's a cartel, obviously you take remedial measures.
Absolutely, sir. So I think we had a question coming from Ameya, who's asking that, can we see bid rigging in insolvency resolution applications? Can bidders make side arrangements for bid suppression or collective boycotts?
See, again, bid rigging is a very wide term.
Yeah.
And it would cover everything.
Absolutely.
So if you're meeting your competitor over a cup of tea and telling him that, look, I'm going to quote this price, in this case, whether I'm supplying services or buying a company, it would still be a problem. Now, the only thing is that whether buyer's cartel is covered by Section 3.3 at this stage. There have been cases when the Commission has said, we have wide powers. There have been cases when the Commission said, no, we do not cover buyer's cartel. But the amendment would definitely take care of this part as well.
Also, I feel insolvency applications are very different from government contracts, because government contracts can be periodic. The main payoff for these competitors when they enter into bid rigging, guys, is that at the end of the day, they'll decide, okay, this time I'll get the contract, in the next cycle, you can bid for the contract and win it. Or let's say if it deals with different jurisdictions, then we can divide the areas between us. But I don't know how far an bidding, colluding an insolvency resolution process will help, because all the parties are very cutthroat at this point and they want to win this particular process.
And I think it is too early to say that. I'm sure that parties and the companies are smart and smarter. They're getting smarter.
Yeah, I was trying to see the payoff, that what is actually the payoff over here for these
No, but
Companies.
if I want to buy a company to
Yeah.
have a bigger presence in the market, then I would like to buy that company no matter what. And then I possibly, I would go to a competitor and would tell him that, look, you come and you quote a certain price. And let's then, see if I get some benefit out of it. But I think these are the questions which are more nuanced. I don't
Yes.
really see whether those things would happen or not happen in an insolvency regime. Practically, whether it can happen, answer is yes. Whether companies would do it, maybe the answer is no, the way you are putting it. But
Yeah, the
obviously,
payoff needs to be seen, that what is in it for the companies to actually enter into this situation.
but again, the point is that if you get into any of those conducts, whether it is covered by the Competition Act, the answer is yes.
Absolutely, absolutely. So, Amya, I hope the question was resolved. Then we have Karan asking a question, I think. One second, I'll just scroll down. Yeah. Recently, CCI did, oh yeah, I think this was the question I asked. That recently CCI did not penalize companies engaged in bid rigging for duping the Indian Railways. Do you think COVID has become an escape mechanism for companies engaged in bid rigging, or is it justified?
Again, CCI has not given any direction that they would not cover, or they would leave the companies, without investigating them. It's a temporary mechanism. I don't know whether next order, in the next order, whether CCI will penalize the companies or not. But essentially, the penalty mechanism is very much there. And leave aside the penalty part, I think the most important part which people forget is the compensation application, 53N. In some of these cases, the compensation, the demand for compensation is much higher than the actual penalty imposed by the commission. Even in 𝗥𝗵𝗂𝗶𝗶𝗁𝗏 case, which is now in the second stage of litigation, I'm not sure whether any of you are following it. But we are seeing a follow-on damage application moved by the Food Corporation of India. And the claim that has been filed by the Food Corporation of India is twice the amount of penalty imposed by the commission. And which is now moving, I think the next stage of that case, possibly in next few weeks, you will hear that, possibly would reach Supreme Court. But yeah, so compensation is a bigger problem for me as on date, as compared to only a Section 27 penalty.
Absolutely, absolutely. So then we have Ruben asking that now with the introduction of buyer's cartel in the amendment bill, do you foresee more such buyer cartels being caught in oligopolistic market bids, or would they also have a safety under the rationale given in the Rajasthan cylinders case, like the sellers do?
The problem in case of public procurement and the buyer's cartel, especially dealing with the public procurement, is that nobody wants to go against the government.
Yeah.
Right. So the sellers are not interested in fighting against the government because essentially they are the buyers and they don't want to fight with their only buyer. So even if they were to think that a particular term is anti-competitive, is wrong, is unreasonable, I don't think that companies would be willing to move to the CCI or any other authority in terms of filing an application or information challenging those provisions or clauses.
Yeah, at the end of the day, they are at their mercy.
So buyer's cartel, essentially in terms of public procurement, I don't think it would only come as a defense. It will not come as an active role by the companies in terms of going after the government entities or the PSUs. I don't really see that happening, practically speaking.
Absolutely. So, Abhishek, I understand that you have a question which is a little outside the scope of our discussion. So, you're asking that if Sir could highlight on laws related to anti-competitive agreements and and JV contracts. So, I think Sir dealt with that part in the first part of our session, where Sir mentioned that, okay, there are two kinds of anti-competitive agreements that we primarily see that come under Section 3. One is 3.3, which Sir dealt with was horizontal agreements, which is basically agreements like bid rigging, where the collusion happens between competitors, and the other one being vertical agreements, where the collusion happens between, or I would say the agreement happens between parties who are at different levels of the service chain. That if Sir is a manufacturer and I'm a retailer, and we have entered into an anti-competitive agreement that will impact the market as a whole. So these are the two primary kinds of anti-competitive agreements that we have under the Act. And bid rigging comes under the first criteria, that is the horizontal agreements. Okay, great. Thanks, Abhishek. If you want more details, you can always get in touch with me and I can explain it to you in a very comprehensive manner. Okay, so Kanika has a question that is there an objective criteria to decide to penalize or not?
Well, I would ask that same question to CCI. There is no answer to it, and
Yes,
we have been
absolutely.
talking about this for
Kanika has
many
hit the
years.
nail in the coffin. It's what we
And
call a very delicate nerve that CCI does not have an objective criteria.
even if they have, we don't know of it. They may say
Absolutely.
that they have it, but I don't know. I don't have an answer to that whether they have it or not.
The closest they got to was with the concept of relevant turnover.
No, in fact, in 𝗥𝗁𝗏𝗂𝗏𝗂𝗏 case, Supreme Court was kind enough to give the criteria on basis of which the penalty should be imposed, aggravating factors and the mitigating
Absolutely.
factors, and that is the closest that we have. But we do not have any mechanism which would say that 10% on this, 5% on
Absolutely.
this, 6% on this, 7% on this. We have no mechanism. We do not have penalty guidelines as on date.
Yeah, also the term says up to 10%, which gives the CCI the complete freedom to decide, okay, which matter can be a 2% penalty or which can be a 10% penalty.
Even on the relevant turnover part, right? They can simply say we do not consider this to be the relevant product. What would you
Absolutely.
do? You would appeal before the Appellate Court and then to Supreme Court and fight it out.
Thanks to you and your team, at least now we have something called a relevant turnover, which was quite a landmark decision that had to be brought in. Otherwise, arbitrary and excessive amounts of penalties were being levied on products and services that were not even part of the collusion.
No, thank
So
you
at
so
least
much, Shweta. Thank you so much.
now that boundary has been drawn.
No, but I think this is the first stage, because that was only the first stage and we are at the second stage of that part as well. I think the only difference here is that a lot of people, when they talk about relevant turnover, they go back to the European jurisprudence.
Absolutely.
Let me, because I'm on this platform, let me also clarify that the entire emphasis in the 𝗥𝗁𝗏𝗂𝗏𝗂𝗏 case was not on the European jurisprudence. It was cited by the Supreme Court. It was never taken as the basis for relevant turnover. The relevant turnover, the concept of relevant turnover was adopted by the Supreme Court on the basis of South African competition law, and which many people don't know of it. And what we argued before the Supreme Court, and we showed them Article 14 of our Act, our Constitution. We showed them the similar article from the South African Constitution. We showed them the doctrine of proportionality, the way it has been implemented and adopted in Israel, in South Africa, and in India. And that laid the foundation for this entire concept of relevant turnover on the basis of proportionality. And Supreme Court, I would say it was a right decision, although many would disagree, went on to the concept of proportionality while imposing the penalty.
Absolutely, absolutely. And Kanika has asked that this part of ambiguity as to how this turnover, like how the penalty can be levied, is not yet given. Can this be challenged as being arbitrary? Like I think by way of, she's suggesting by way of a writ petition that needs to be filed.
So, I think it can be done, undoubtedly. There is no way that you cannot do it. Also,
I would say never say never.
And you can, in other cases, argue that in Excel, you said that come out with the penalty guidelines. It was on the year 2017 when the Excel was pronounced. It is now, over 3 years. CCI has not done anything. You can do all of those things. I know the answer. CCI would say we are examining it. We have a rational system of imposing penalties. So don't worry, and please don't, force us to get out something like this. And that would be mostly it. I think we would still need some more time in terms of some more cases which are getting argued currently to have clarity on those ambiguities that we're talking about.
And this is something actually even the, like I was part of one of the CLRC meetings that were happening. And this was one of the debated topic and something that law firms were pressing, that we need to have some sort of guidelines for the penalties that you're levying. And their defense to that was that, look at the nature of the law. It has only been up to, I think, 10 years that, we've come out with proper orders. And this law is a creature of evolution, that with every case, we're coming out with a more like a varied description. At this stage, if we draw a bright line test for penalty, then it might act as a deterrent for other cases. That was CCI's justification on it.
So I think in the CLRC report, the discussion, the way it went, I was not part of the CLRC committee. I wasn't present there, but what I have heard is that obviously there was a lot of reservation and resistance to relevant turnover as well, and which has been quite diluted under the new discussion of the debate which came out after the CLRC report. So whether there is a CLRC report or no CLRC report, I don't see an answer coming out of these reports at all on this aspect. This is an issue which has to be addressed by the courts, by the bar, and by the bench. And then only you will have the jurisprudence which will be there in the market, and for CCI to follow that to the core.
Absolutely, absolutely. So Kanika, I hope your question has been answered. Thank you so much. Quite many pertinent points that you have raised with respect to the law. So guys, I think I've covered all the questions that were asked by the students here, and I hope they have been successfully answered. Okay, Bhavya, the thing is, your question is a little bit outside the realm of our topic today. I know your question is based on technology law. So what I can do is I can pass on your question to sir and have sir's answer given to you separately, if that's okay. Okay, you can give me your email ID and I can pass on the question to sir and then reply to you on the same regarding the scope of technology law and tips with respect to how to proceed with the field. Okay, so if anyone else, I think all the questions have been taken care of. We're also on 3:15. We have another session starting up at 4. So thank you so much, sir, for this very crisp and a very insightful session on bid rigging. Especially the case laws have helped a lot of students because they said that at least now they can take a note of the case laws. I suggest all of you please go and read these cases that sir has given. It's a very good dossier that he has prepared with respect to bid rigging. And it will be very helpful for you guys when you are dealing with a matter of, let's say, bid rigging, or even dealing with a government contract for that matter, and you're advising a company as an in-house counsel. So thank you once again, sir, for gracing us with your presence and for taking out the time for this session. And we hope that you take future sessions as well on competition law.
Thank you so much, Shweta, for inviting me here.
Thank you,
all
sir.
the very best.
Thank you, sir.
Thank you so much.
Thank you all of you for your patience. And thank you for attending the sessions, and we'll see you for the next webinar. Thank you. Good afternoon.